Be seated. The next case we have is, looks like it has been allotted 10 minutes aside, and it's Jack Loans versus Wastage Systems. Mr. McCabe, you may proceed.
Sure. Thank you, Your Honor. May it please the Court, my name is Bill McCabe. I represent the claimant Jack Loans. I'll reserve 2 minutes for rebuttal. In this case, the judge of compensation claims found that the claimant's claim for permanent total disability benefits filed on January 7, 2005 was barred by the doctrine of res judicata because of a previous September 4, 1990 order denying a claim for wage loss benefits. We submit that the judge has erred. Now, res judicata bars a claimant from seeking a benefit when he could have but failed to seek that benefit in a prior hearing. However, it doesn't apply if the claim was not mature at the prior hearing. It also does not apply when to invoke it would work an injustice. Now, in this particular case, the judge found that the PTD claim was mature at the prior hearing because the claimant was at MMI. But for a 1985 accident, which is what this was, just because a claimant reaches MMI does not mean that a claim for permanent total disability benefits is ripe. And I've cited a couple of cases that hold that MMI is not synonymous with permanent total disability, particularly for a pre-January 1994 case. The reason being, in part, is because there were different ways you could prove entitlement to permanent total disability back in for an 85 accident. One was medical evidence of disability. One was a lengthy but unsuccessful job search. One was a combination of medical testimony and vocational testimony. So simply because the claimant was at MMI and seeking wage loss does not mean that his permanent total disability claim was ripe at that time. I could find no cases. When I did my brief, I found 2 cases that kind of held the opposite, where they held that a claim for permanent total disability did not bar a subsequent claim for wage loss. Tara Saeed has filed a supplemental authority where this court dealt with a post-January 1st, 1994 accident. And in that case, this court found the claimant had expended his 104 weeks of temporary disability benefits. This court found that the fact that he went to a hearing, I think seeking medical benefits after his 104 weeks were up, did not bar a subsequent claim for permanent total disability on the doctrine of res judicata. Of course, the post-January 94 cases are a little bit different because there you can actually try to get PTD even before you're at MMI if your 104 weeks are up and you can prove you're going to be permanently totally disabled by the time you get there. So we really think the judge erred in that issue. The second part of my argument, and perhaps the more difficult one, is in the prior 1990 hearing, the parties stipulated that the claimant was at MMI on March 13th, 1989, and the judge then made a finding that the claimant failed to prove that he had a permanent impairment. And I will admit and acknowledge the cases cited by Mrs. Saeed that permanent impairment is one of those non-recurring issues that can be barred by the doctrine of res judicata. But my response to that is that res judicata will not be invoked where it would work an injustice. And in this particular case, this seems like one of those situations where it would work an injustice, because this claimant allegedly was at MMI on March 13th, 1989, but the carrier has continued to provide medical and chiropractic treatment for him for 15 years.
Why? Excuse me, counsel. I saw that argument, and it wasn't in the record why they were continuing to do that. Was it out of the goodness of their heart?
Well, they accepted as compensable the lower back and lower radiculopathy injuries. Why they continued to provide it, they'll tell you that it was palliative care. I don't know if the record specifically shows why they continued to provide it, but the fact of the matter is that they did.
Were they legally required to provide it?
Well, I mean, my position would be that they were, at least in the latter years, because the judge, one of the doctors, Dr. Hecht, who's a chiropractor, opines that this claimant has a 12% permanent impairment rating because of the injury sustained in the accident.
That was 12 years after
That
this
was
possibly voluntary medical care was provided.
possibly, but the fact of them, why they provided it, I don't know. I mean, the record doesn't say. But the fact of the matter is that they did provide it. The claimant sees a chiropractor twice a week. There's 19 pages of medical bills and stuff in the record, or of linear entries of chiropractic care. They also authorized a pain management physician beginning in the year 2000. The pain management physicians recommended a morphine pump. The claimant finally saw a vocational counselor in 2005. Never saw a vocational counselor before. The only thing the carrier provided in that aspect was 6 weeks of work hardening way back when. So when you have a claimant who's had 15 years of medical treatment, the authorized treating doctor, who's the chiropractor, says that the claimant has a 12% permanent impairment and that the claimant is disabled, totally disabled, and the vocational counselor says that the claimant is totally disabled. It would seem that this is the classic case where it would work an injustice to preclude the claimant from litigating the claim for PTD benefits and whether or not he even has a permanent impairment at this time. So I guess I'll reserve the rest of my time for rebuttal.
May it please the Court? I'm Tara Saeed on behalf of Waste Aid Systems and Liberty Mutual. I wanted to first address the concern, Judge Bernstein, that you had, and the question you had raised about why did the employer carrier continue to provide medical treatment all those years. As is well established in Florida law, in the statutes and also in the case law, an employer carrier is required to provide care for a compensable accident. There's no question that this was a compensable accident. Claimant did reach MMI in the early order in 1990 from Judge Lazara. He indicated that the parties had stipulated the claimant was at MMI with no rateable impairment rating. But there is nothing to say that if the claimant goes on to say that I have these subjective complaints, even if there's no objective findings, I need to see a doctor. I need to see a doctor. His attorney contacts the employer carrier and says, my client still has complaints. He wants to see a doctor. We are required to continue to provide that, even if it's palliative care. It can go on, as in this case, for 15, 20 years. If we didn't, I'm sure we would have shown up with a petition for benefits saying that we were not providing it. So long as he had that, he has to pay a $10 copay, and he can continue to see the doctor. It doesn't mean that even though he gets care over all this time, that the care is curative in any way, but that is palliative because he has these subjective pain complaints. And furthermore, the employer carrier would not want to expose himself to any kind of a bad faith issue for not providing care because of the original compensable accident. So rather than, do the wrong thing, the employer carrier did the right thing. One of the first things I wanted to address in here, in the original order in 1990 that Judge Lazara had entered, he found that there was no permanent impairment rating, and there was actually 2 dates of accident, 8/15 of 85 and 1/7 of 86. As mentioned, the parties had stipulated to MMI as of March 13th of 1989. During that time, the claimant, there was an earlier deposition, and then there was a later deposition of the claimant taken in in May of last year. In that deposition testimony, the claimant states, there's a couple different dates here I wanted to go through. We have an MMI of March 13 of 1989. He says, and I quote, "I quit looking for work when my check stopped." The employer carrier had stopped paying the claimant on March 15th of 89 when he had reached maximum medical improvement. So during that time, he had to go out and fill out these job search forms and showing the employer carrier that he was not able to find work, and because of that, he had no other wages, so therefore the employer carrier should be paying. In his latest deposition in May 6 of 2005, he said, "I have not filled out any application since 1992. So prior to the original trial in 1990, he had said that he could not find work, he had looked for work, and he quit looking for it at the time that the checks were cut off. Then he's saying later that he has not filled out applications since 1992, so prior to the date of his original MMI, and after that, the testimony in the record shows that he looked for work. So the question then comes, what was the statute in effect at the time that would qualify him either, to show that the claim for PTD was right, due, or owing at that time? What we would look at, Your Honor, is first off, Statute 440.15 sub 3 in 1985. It says that a claimant is entitled to wage loss benefits if there is some permanent anatomical impairment and a reasonable work search done. Well, we can stop at the first point because the judge specifically found there was no rating. So now we look over at Florida Statute 440.15 1B 1985. It says that PTD is found determined in accordance with the facts, and under the Herrera versus Hojo N case, there's 3 different ways a claimant can show this. Part of this is showing the burden that he is unable to perform uninterruptedly even light duty work. And as Mr. McCabe had mentioned, there's 3 different ways: through medical evidence, lengthy but unsuccessful job search, and combination of medical evidence and vocational evidence. And these are either or, it's not and, all these 3 situations. So Mr. McCabe's argument is that, yes, he was at MMI, but that doesn't preclude him from, filing for PTD. That's correct. But at that time, the evidence shows that it was ripe to file because he had done a job search. He testified previously and in his deposition in May of 2005 that he had looked for work prior to the MMI and after. So there's the record showing, I've looked for work, I can't find work, I can't do my past substantial gainful employment, and I'm at MMI. So we would contend that it was ripe then. Another point that was brought out was the chiropractic care that he got all these years. If you take a look at the extensive notes that are in the record, it shows all the way from January 16 of 2002 until 11/4/2002. The notes specifically, there's one line in there where the chiropractic, Dr. Hack, wrote, he is permanently disabled. He is permanently disabled, repeatedly. No claim is ever brought for that. And so, it shows that this was right, due, and owing. And this is after that original 1990 hearing. But it shows that the doctor was even recognizing at that time that he potentially could be permanently, totally disabled. Hint, this is the time if you want to request the benefit. But prior to that, he was at MMI, and he showed that he had done a job search and couldn't do his past substantial employment. So if he was, that would have been the time to raise the issue on the request for permanent total disability.
Because he didn't, it's barred by res judicata?
Well, if we look at that...
That's the question I wanted to ask you, because the concepts, and I don't blame you, either one of you, for what you've argued in your briefs, but it seems to me the concept is thoroughly confused in our case law. Res judicata is the preclusive effect of a judgment or a decision by the court.
Correct.
Seems like if you have a claim that could have been raised but wasn't, that's not res judicata, that's waiver.
And technically, you're exactly right, Judge Padovano. And when you take a look at it, it's kind of a convoluted concept when you apply it to workers' compensation. Because traditionally in the case law, it's not so much that an issue has been raised and was litigated. There's a line of cases that talk about you can't do this piecemeal litigation, bring up things later. But in workers' compensation specifically, it has been when a benefit was right, due, or owing, that's when the judges seem to turn to the concept of res judicata, saying, this is the time to bring it up. You didn't bring it up. All the issues are set in place for that.
Seems like the wrong term to me, but I accept the fact that it is part of our case law, and I don't blame you for making the argument that way, or the judge for deciding it that way. And I'm certainly not
and I do agree, it is a very convoluted when you transfer it over.
Well, I was trying to, it just confused me. I was trying to figure it out. I was trying to figure out, well, are they saying that because there was a finding of no impairment, that particular finding bars the subsequent claim? But I don't think that's not your argument, is it? I mean,
no, Your Honor.
It's really a waiver argument,
exactly.
Except that we have called it res judicata for whatever reason.
Correct.
Okay.
But it also, the underlying evidence does support that he did not establish a claim for permanent total disability. One of the issues that Mr. McCabe had brought up also was the fact that the employer carrier continued to provide this medical care through a chiropractor, and then at one point he was referred even over to a pain management physician. So therefore, some of the case law says, if you can show down the road that there's new evidence or something to hang your hat on to show that there is a change in circumstance or fact, then that might not bar the bringing up the permanent total disability at that time. My response to that would be, though, there is no new evidence or new findings. If you look specifically to the, and Employer Carrier's independent medical examiner, Dr. Chamont, I believe I'm saying it correctly, it's in volume 6 and his report's at page 1008. He says, quote, "It's inexplicable to me from a medical standpoint how he has had medical treatment for so many years with no evidence of any permanent injury as a result of the accident. It's an appalling overuse of chiropractic treatment." He says that Dr. Haynes is a physician that had recommended the morphine pump. He specifically said that the recommendations for the morphine pump and interventional procedures are for unrelated conditions. This claimant had had a stroke, he had had heart problems, he had been at MMI, he said specifically, "I find for 20 years. And I find that he is capable to perform his previous job. There's no rateable impairment as a result of the accident. He has psoriasis. And in fact, he has cardiovascular issues that he said this ongoing chiropractic care actually could have been aggravating all along, because as you do these manipulations, it can affect different parts in the body and aggravate other conditions." He says, quote, "My opinion, his spine does not merit disability." So there is competent medical evidence in the record that shows that the doctor, there is evidence to refute that there is any new findings, because there are no new findings. This is an individual that has a lot of personal conditions. Yes, he had a accident and there was an injury from it, but he has complaints of the whole left side. There's no rateable conditions from it. And as the natural aging process goes, he's also a smoker, and that can affect, the doctor comments on that, on how their body can heal and how it can degenerate over time. Over the years, he's gotten worse, but there's no objective findings, even as late as when Dr. Chamont does his examination, which is in May of '05. So there's nothing new. Also, if there were new change findings within the 2 years of that initial entry of the order, why was a petition for modification not brought up? Why was there no challenge against any kind of, the MMI really wasn't the MMI? So that's kind of the condition, the way that Employer Carrier is looking at this. In Judge Hafner's order, she specifically found that he was at overall MMI back then. Everything has been palliative along the way here. It was right, you were owing way back in 1990, and nothing's changed at this point other than the natural aging process. So the Employer Carrier would take the position that the judge's order should be upheld.
Thank you.
Thank you.
I want to address that last part a little bit about the disability. The judge, I mean, if you were to agree with our position, then I think the appropriate thing would be to remand the case and have the judge decide whether the claimant's permanently totally disabled or not, because the judge specifically makes a finding that having determined the claim for PTD is barred by the doctrine of res judicata, it is not necessary to recite the evidence regarding claimant's disability. So she didn't make any attempt to determine whether or not the fact that this man's been getting treatment for 15 years, whether the injuries are compensable, or whether she would rely on the IME that they had from Dr. Chamont. So, and then as far as the January 16th, 2002 was the first date that the chiropractor indicated the claimant was permanently totally disabled. That's the date we suggest that the claimant should be found PTD, but there was no waiver or anything after that date either. The claimant did file about 10 petitions for benefits for medical treatment, but never had any of them go to a hearing or anything. So,
Thank you
very much.
Thank you, counsel.